entrepreneurs, welcome back. Stephen Jordan here, business lawyer, practiced over 18 plus years, practiced with prominent large business law firms, and served as in-house counsel for successful corporations for a number of years, worked with publicly traded companies as well as small mom and pop type businesses. Thousands and thousands of transactions over the years, exclusively doing business law, which includes intellectual property and real estate, but business law attorney. Quick disclaimer for you is the content in this video and in my other videos, it's not legal advice and it's provided for informational purposes only. Okay, the topic for this video, and I got to keep it to a minimum, as always, so I'm going to hit the high points. This is about piercing the company veil, or piercing, historically is known as piercing the corporate veil, but since the advent in the 90s of limited liability companies, it's not piercing the corporate veil anymore necessarily exclusive, it's piercing the company veil. So what does that mean? That means any business out there, the primary reason businesses or small business owners decide to create an entity, corporation, whether S Corp or C Corp or a limited liability company, is for the reason of limiting their personal liability and exposure. They don't want the risks and liabilities and financial losses or obligations of the business to come and get to them personally. And so they put the veil, the company veil, between the business operations and them personally to protect everything personal. So when you're signing on behalf of your company, LLC or a corporation, always sign on behalf of the company and not as a member or as a shareholder. You sign in the capacity that you hold, the office that you hold for the entity. Always. That's how you sign it. You sign it, Joe Smith as manager for XYZ Limited Liability Company. So what are the things the courts are more likely to pierce the company veil when certain situations exist. For example, one, if there's no real separation between the company and its owners. For example, you can't pay personal expenses with the company's account. The more you get into commingling between personal and the company, you're running into risk of a court being able to pierce or plaintiffs to pierce your company veil and get you personally. So you don't want them to be able to reach you personally. So maintain that separateness. Always have a separate account and keep all transactions separate between the company and what you do personally. And everything you do on behalf of the company, sign in your capacity as officer on behalf of or for the company. So the other way that courts are more likely to pierce the company veil is when there's company actions that are wrongful or fraudulent. For example, if an owner knows that the company can't pay certain obligations that it's entering or deals that it's entering into on behalf of the company, then the company or the court is more likely to pierce the company veil and get them personally. So that's a no-no. Okay, factors that are considered by courts. Now this varies state to state, jurisdiction by jurisdiction, so there's going to be variations, and so and every business is specific, every state is going to have variations on legal principles. So, but these are some of the key essential things that courts will look at. And states, for the most part, there's a great uniformity, with exception of a lot of areas of law, business or otherwise. But always recognize that each state's going to have differences. So factors considered by courts when considering whether or not they pierce a company veil and get the owner personally for risks or obligations or losses on behalf of the company are whether or not the company engaged in fraudulent behavior. As I already talked about, that's a no-no. You know that the company, anyway, that's a no-no. whether the company engaged in fraudulent behavior. Another factor considered by courts is whether the company failed to follow corporate formalities. Now, every company should have certain company documents in place. They should have, LLC should have an operating agreement, and it's going to say when managers meet, it's going to say when officers meet. There should be minutes from meetings, unanimous consent resolutions signed on behalf of the company. These formalities have to be followed. There should be, at a minimum, an annual meeting held on behalf of the owners and on behalf of the whatever the management body is, directors with a corporation or managers with an LLC. So each owners and managers need to have these annual consents or minutes, resolutions incorporated into their company record book. Every company should have a record book that has all its principal and organizational documents in it. And the minutes and resolutions of the company should absolutely be maintained and recorded. So that's key. And companies fail, especially small businesses fail to do that all the time, and it can have disastrous results. Another factor considered by courts is whether or not a company was inadequately capitalized. If you start a company that's dealing with toxic waste and you didn't have proper insurances in place, or you just didn't fund it for the nature of the activities taking place, then the company is more likely to have its veil pierced and the individuals reached personally. So make sure, based on the nature of your business, that company is adequately capitalized from the beginning. And then another factor considered by courts is whether one person or a small group were in complete control of the business. So if there's one person in control that's making all the decisions, it's at greater risk of it being potentially pierced, or a small group of people, then its likelihood of being pierced is greater. Now, because if it's managed by a board of 7 or 9 people, it's getting larger where the decisions are made by a body, and so you can't point to one or a small group of individuals that are responsible for the business activities. Another thing that you really want to look at, don't commingle assets. Company assets are in the company name, personal assets are in the personal name. The expenses and maintenance of either are not commingled. If there's a loan on behalf personally of an owner to the company, you need to paper these things. You need a promissory note. There needs to be payment terms. There should be at least the lowest amount of insurance, as would be imputed by the IRS, incorporated into the promissory note. So you need to paper how money's flowing. And even in between companies, it happens all the time. People will create separate companies, maybe, and some are doing different business activities, or they're owning, this one owns a commercial complex of 3 units. This one owns a duplex. This one owns, and so they're separating, so the risk, which makes sense, but you can't start taking the assets from one and bringing it to the other, making it available from A to B to C and to different entities, because intercompany piercing can happen. So again, don't commingle assets, paper all activities above board, and that's critical. But otherwise, you're running the risk of having your company veil pierced and the courts reaching that. So that's my brief summary on piercing the company veil. I hope you found that of value. I've created a comprehensive business guide that I make available to businesses. $19.99 is the cost. It covers a host of topics. I can email you the table of contents so you see the breadth of what the business guide covers. You can email me for that. I also provide business consulting services at a rate far below what business law firm experienced business attorneys would charge, and probably a fifth or less is what my cost is, because I don't have the overhead. I don't have the huge cost of the bricks and mortar and administrative staff and all that kind of stuff. So email me, and I'm glad to discuss that further with you, but I do provide those services. So thanks for tuning in once again, and I'll be posting, and I am posting a number of videos on a number of various issues that relate to business and law. And any questions that you have at any time, I'm very responsive to emails. Feel free to email me, StephenJordanESQ@gmail.com. Stephen, STEPHEN, JordanESQ@gmail.com, and I'll happily respond to those. So this is, once again, Stephen Jordan, and I'm wishing you all prodigious business success. So go out and have a wonderful day. All right. Thanks very much.